Well, good morning. I'm Aaron Hall, attorney for business owners and entrepreneurial companies. All right, first question we have for today. What is the biggest mistake people make in sales? All right, I'm going to tell you an embarrassing story. This is a story of the biggest mistake I made in sales, and it might be one of the most important sales, if you will, that a person encounters in life. I'm using the term sales broadly because I was not just asking for a small transaction. This is the story of how I messed up when asking for my wife's father's permission to marry my now wife. And did I mess up? This is so embarrassing, but it's a great story, and it ends well. So I decided I was going to ask my wife's father if I could marry her, and I didn't know what he would say. I thought it was likely that he would say yes, but you never know for sure. And this is a really big deal, and I wanted to propose to her. So I did tell her in advance that I was going to be talking with her dad, and it was very clear that I was going to be asking his permission to propose to her. Obviously, I'd never done this before. I had no experience. This is the first attempt, and so you can't possibly know how to do this well if you've never done it before. And that's the importance of experience. Hey, if you're going to do sales, the more practice you have, the better you get. But okay, so what do? I need to find an excuse to go over and talk to him. So on my drive over, first off, I suppose another lesson here is prepare in advance. I didn't really have a plan as I drove over there. I thought maybe I would run into, like, I could pick something up at a bakery. This was before Google Maps though, and so I just picked up some, I happened to pass a gas station. I didn't even know where a bakery was, and so I picked up some donuts there. Looking back, I don't know what I was thinking. But I showed up at the door and just said, hello, I wonder if and they said, oh, Kate's not here. Were you supposed to meet her here? And I said, oh, no, I just came by to stop and talk with you guys. And they said, oh, okay, come on in. And then after chatting for a little bit, I couldn't find a way to bring up the question. And so small talked for a little while and just couldn't find a good way to segue to, oh, by the way, could I marry your daughter? Or may I ask for your permission to propose to your daughter? And so having not figured out a way, I drove away. And I went to my wife's friend's house where she was. And she goes, how did it go? Did it happen? I said, it didn't come up. And her eyes widened. And she said, it didn't come up. You make it come up. And what I didn't realize is she was in significant anxiety waiting for the result of that conversation. And I remember her friend Krista right next to her said, you got to go back and make it come up. So, and I needed it to be done. We needed to figure out one way or the other. So I drove back over, and long story short, I asked his permission. He was very gracious. He said, I can tell that she is very happy with you, and we would be happy to have you as part of our family, and we wish you the best in your relationship. What's the lesson here, though? The lesson is to ask for the sale. Have you ever noticed that people who start out in sales can build relationships and they may talk about the product or the service they're selling, but they don't actually close the deal? When I was running for public office decades ago, I learned an important lesson. You should always ask people for their vote. And it felt awkward. You don't want to do that. But I found a nice little phrase from a political mentor of mine. He just said, when you're speaking in public and there's not an opportunity, say, I respectfully ask for your vote. And what that does is it gives the other person an opportunity to accept the invitation to a relationship with you. And if you don't at least give them the opportunity, how is it that they'll take that opportunity? It's very rare for a person to, on the other side, to initiate, hey, I want to buy from you. So whether you're asking for a person's vote, or a father for his daughter's hand in marriage, or a prospective customer or client to participate in a relationship with you, to utilize your services or with your products, the boldness of asking for the sale is such an important part. And it doesn't have to be done obliviously. It doesn't have to be done in an awkward way, but in a gentle, kind, humble, and respectful way. You can ask for a person's participation in a relationship with you, whether that's buying from you, or a partnership with you, or an investment with you. And by the way, you can do it with confidence when you know that it will provide value to them. And so we've bypassed what leads up to the ask. Sometimes the other side knows the value that a relationship would mean, so it's clear by the time you ask. Other times you need to articulate that, or even better, ask questions so they can articulate for themselves what the value would be. Without going into the other sales concepts here, this was one of the most embarrassing or most the biggest mistakes I've made in not asking for the sale the first time. And then when I went back, I did. And it may seem a little inappropriate to compare asking for the sale of a product or service to asking a father for his daughter's hand in marriage. But it was the one mistake that I remember and my wife doesn't let me forget, because she has me tell the story from time to time. It was one of those mistakes where I'm glad it turned out well, but I hope you can learn from my mistake and ask for the sale when the opportunity is right. You don't want to have to go back and ask for the sale. All right, next question. What is the biggest mistake I made when firing employees? I've probably hired well over 100 employees. And in that time, statistically, you run into some employees who don't do the job well. They don't do it right. They're not a good fit for the team, something along those lines. And I remember speaking with an HR expert one time. Her name was Lori. And Lori taught me a brilliant concept that I want to share with you today that makes it so much easier to let employees go. It removes some of the awkwardness and pain for the employee leaving. It removes some of the awkwardness and pain for you as the one letting them go. And it protects you from a legal standpoint as well. And here's the technique. She said, whenever you let somebody go, remember, nothing you say is going to make them feel better. So don't drag it on, don't compliment them, don't sit and say a bunch of things. That creates a confusing message, and that whole conversation is awkward. They just want to get out of there. So make it short. And then the second piece, and this is the most powerful, she said, use this line, for the reasons we discussed. I'll give you an example. Hi, Jim. I wanted to talk with you today. This is a difficult conversation, but I wanted to let you know, for the reasons we've discussed, we're letting you go. And then typically you would say, if you want, you can elaborate for a sentence or two more, and then you say, you can meet with HR about any procedural questions you have, but here are the next steps, and then you lay those out. For example, you'll be given an opportunity to go to HR and clean out your desk and take your personal belongings, and this is effective immediately. It doesn't always have to be effective immediately, by the way. I've had many employees where I give them days or even weeks. It really depends on the maturity level of the employee and the risk of the employee. But here's the magic of this phrase, for the reasons we discussed. And why is that so important? Well, first off, it means that you have already discussed those reasons, that the reasons are very clear. And what that entails is a prior meeting where you explain to the employee, here are the expectations of the job. And here is how your performance is not matching those expectations. For you to continue to be in this role, your behavior needs to match the expectations. And so that way, when you have that conversation about letting the person go, and you say, for the reasons we discussed, you are referencing the expectations for the job and how their performance or behavior is not matching those expectations. Now, obviously, if they steal money or do something like that, you don't have to have a conversation about how their behavior doesn't match the expectations. The expectations were clear. They're written in the law. Often they're just let go immediately. But where their performance is below what is expected, but not necessarily intentional or not egregious or not a violation of trust. But let's say, for example, you expect a certain level of productivity and they're below that level. You want to make it very clear what the expectation is. Sometimes in that initial conversation, you even ask, I want to make it clear, or I want to make sure that I'm clearly communicating what that expectation is. Could you share with me what you're hearing from me? And that way it's coming from their mouth. You might even consider following up with an email afterwards that says, hi, Jim. I appreciated talking with you today. For your reference, here are some of the key points regarding the expectation for your role. And it's important that your performance align with that expectation. And then you might list some bullet points regarding the expectation. That way, when you have the next conversation and you say, for the reasons we discussed, Jim or the employee knows exactly what you are talking about. The performance of the employee isn't matching the expectation of the role. And you had an opportunity to correct that, and it wasn't corrected. And you might even say that for the reasons we discussed, the job requires the performance at this level or this sort of behavior. And your performance hasn't matched that over the last few days. So we're letting you go. And you can give them an opportunity to ask any questions they have. But That line, for the reasons we discussed, is one of the greatest little nuggets that I learned about how to make a firing of an employee more effective and clear and eliminate some of that awkwardness of dragging it on and having to talk about all of it. You don't want to get into all the details. You just simply reference it for the reasons we discussed. In light of the fact that your performance has not matched those expectations, we're letting you go. So if you have questions about any of this, feel free to add those in the comments section below. Letting employees go is one of the hardest jobs of a business owner or CEO. And I'd be happy to see if I can answer your questions, whether it's around best practices or perhaps around the law. But keep in mind, the law is different for every state. So sometimes on a generic or educational channel like this, we need to deal with generalities rather than specific statutes and employee rights, which vary state by state. So feel free to add your questions in the comment section below. Next question. Do you need a contract to ensure you get paid in a partnership? So imagine you have an important business relationship. It might not technically be a partnership, might be a joint venture, it might be a sales rep relationship, but whatever this ongoing relationship is that you have, do you need to have it in writing? Well, most lawyers will tell you, of course you have to have it in writing. Every contract has to be in writing. But I think it's important to acknowledge that not every relationship is big enough to be in writing. Often the stakes are not high enough to justify spending the money to have a lawyer draft up a contract. Here we are in 2023, and let's say it costs you $1,000 to have a contract written up. And let's say the relationship that we're talking about having put in writing has a benefit of $3,000 and a risk of $3,000. Because say, for example, you're hoping to get paid. Does it really make sense to spend a third of that, $3,000, on having a contract? Well, here are some of the factors I'd recommend considering when determining whether to actually hire an attorney or not. First off, do you already have leverage in the relationship? For example, if you're providing work each month in exchange for getting paid each month, and they need your work, you've got some leverage there because the other side needs you to provide ongoing work. So if you have leverage, you're far more likely to get paid than if you just, for example, send a product and you're hoping the payment comes in for that. So if they need you for some reason, you may have leverage, which suggests that perhaps you don't need to have that contract in a formal written form. Second, based on what you know of the person, are they likely to pay? And perhaps more relevant, would a written contract improve the likelihood that they are going to pay? Sometimes a written contract doesn't matter either way. Maybe it's a family member of yours and you know they always pay. They have high integrity. Or maybe it's let's say it's a large company with an important reputation in the marketplace and plenty of assets. Statistically, they're far more likely to pay than some startup company with barely any assets and no reputation. So you might consider whether you actually need to have a contract based on their likelihood of paying and whether that is affected by having a written contract. Next, I would look at, is there a lot of money at stake? If there's a lot of money at stake, that suggests you should have your contract in writing. If there's not, then that suggests having it in an email with bullet points or something like that is sufficient. Now, let's say you decide that it just doesn't make sense to hire an attorney to put together a contract for you. At that point, you might be tempted to use a template online. And I'd encourage you not to do that because templates are often include terms, a bunch of terms that are standard for a particular relationship. But the important question is, are they relevant to your agreement with the other side? The purpose of a contract is to put the agreement and the terms that you've both accepted in writing, not to adopt a template. A lot of times clients ask me, hey, can you send me a template for this? Well, I have thousands of templates, and often I will spend the first 30% of my work for a client understanding what are the terms of their engagement, and then trying to find the closest template that matches it. But always I have to make changes to the template because I have never had a template in one situation that works for another situation. Even clients hiring a CEO or hiring an independent contractor or agreeing to license a trademark or the sale of a business, never once have I not had to modify the substantive terms in the contract. But you might be saying, okay, well, if I have to decide between paying an attorney and having nothing at all, I guess I'll just have nothing at all. But that feels really ineffective and risky. And so if you're in that situation, I have one new idea for you, which I have been incredibly impressed by. This is an option that never in history has been available to people until 2023. And that is using AI to put together a rough contract for you. I've spent extensive time using ChatGPT. I've spent some time using Claude AI. Both of them are surprisingly good at helping you at least get some basic terms in place for a relationship. Now, I'd never rely on what AI puts together for a large contract because every time I ask AI to put together a contract, it's missing a number of key pieces. But it's usually better than an email with just some bullet points in it. And so I have some other videos talking about how to use AI, but I think the key here is to put into ChatGPT or Claude the scenario you're dealing with, the names of the parties, the important terms, and then you can even ask it, what other terms should we consider for a contract of this type? And then have a little conversation with AI about what else should I consider? Am I missing anything else? Are there other factors I should consider? And then when you get done with that conversation, you can say, using the information above, please draft a contract for me and this other party. And then, of course, review it. Now, should you run this by an attorney? Absolutely. Is this a perfect contract? No. But it's better than an email with some bullet points written by a non-attorney. And so if you are in a situation where the transaction is just too small and it doesn't justify spending money on an attorney, better than having no contract at all is a contract that you've put together and understand using the power of artificial intelligence. ChatGPT, Claude, Llama, or any of the others that are available. the ChatGPT-4, or I'm sorry, it's called GPT-4, is probably the best I've seen right now, but all AI keeps improving and changing. So if you are a small business owner and you can't afford an attorney to draft a contract, take the approach I've discussed here to get together at least a rough contract using AI. And if the stakes are high, or if the other side is unlikely to pay, or if you don't have leverage, those are great reasons that justify paying an attorney to draft a contract for you. All right, next question here. All right. What is fraudulent misrepresentation? Well, fraudulent misrepresentation is the same as fraud. But what I'm going to talk about today is fraud in the historical sense, which is in the common law in all states. It also is recognized in statute. Now, I said a lot there. Let me unpack the different pieces of that. First, before we even had statutes in the United States passed by Congress or the legislature, the courts in the United States adopted the concepts of common law. Common law is a carryover from England, and it simply said, if a decision was made by a judge in a prior court, we will follow that decision here. And that particular decision becomes part of the common law. It's the law that's common to everybody, and it's kind of based on logic, reasoning, common sense, that sort of thing. So in the United States, we have common law fraud. But then legislatures in the various states and Congress passed laws. Those laws became statutes. And so we have statutes that prohibit fraud as well. We have statutes that prohibit fraud related to wages, related to attorneys, related to all sorts of different scenarios. And so you have statutory fraud. That's all these laws passed by a legislative body and enacted into law. And then you have still the common law fraud, which was in place prior to statutes. So when you sue for fraud or fraudulent misrepresentation, as it's sometimes called, you often consider, do I sue for common law fraud, statutory fraud, or both? And usually it's both. By the way, it's also usually negligent misrepresentation. So let's compare fraudulent misrepresentation to negligent misrepresentation. Fraudulent misrepresentation is where there is intent to deceive or a reckless disregard of the truth in the deception. Whereas negligent misrepresentation is where a reasonable person should have known the answer, but you weren't reckless, you just were negligent. All right, so whether there's intent or not is an important part of fraud. Let's talk about fraudulent misrepresentation and the specific elements to prove that. And we'll just set aside negligent representation for another day, because today it's about fraud. What are the elements? All right. Well, first, there has to be a representation by a party. So let's say that's you, regarding a past fact, not an opinion, which is material and susceptible of knowledge. So if I say, for example, next Wednesday, it will rain. Well, that's clearly a factual statement, but it's not a past fact, it's a future fact. And so it's understood in the law, and should be understood by the person you're talking to, that you can't necessarily with certainty know if it's going to rain. So if it doesn't actually rain, that's not considered fraud. It has to be a past fact or a present fact. If you say, for example, I will be in England next Monday. Well, you might have plans to go to England, but because it is a future event, it is generally not considered fraud because you might be agreeing to go there. So there might be a breach of contract, but because it's a future event, it's not necessarily fraud. Now, if you knew for a fact that you had no plans to go to England and you said, I will be in England next Friday or next Monday, that's fraud. Because you, with intent and knowledge, you made a statement, even though it's about the future, you made a statement that you knew was false in order to deceive the other person. Okay, so it has to be a false statement. By the way, and it has to be a fact. If I say to somebody, you are an idiot, and the other person says, well, I'm not an idiot, and so that was fraud. The defense to that is, well, no, it wasn't a statement of fact. It was a statement of opinion. If I said to or let's put it this way, if someone said, Dave is a child molester, that's a statement of fact. So that would be usually considered fraud, and assuming Dave is not a child molester. Likewise, it would be defamation. By the way, you can have a lot of different claims for the same event. So you might have fraudulent misrepresentation, negligent misrepresentation, statutory fraud, defamation, etc. But if you said, Dave is a clown, he's a goof off. Well, if you are intending to essentially say that a person is careless in their conduct, and always cracking jokes, even if that person isn't, that's probably more of an opinion statement rather than a fact. Interesting story. Elon Musk tweeted that a guy was a pedo guy, and pedo was short for pedophile. And the guy sued and lost. Now, the general rule is that if you accuse somebody of being a pedophile, that's a factual statement and that's defamation. But in this case, the court determined that it was understood this was just a derogatory name for somebody and not actually based, not a statement of fact about them. Nobody really thought that that person was a pedophile. It was just more treated as an opinion. We're getting into defamation law, but this is a relevant analysis for fraud as well. All right, next, the representation has to be material. So let's say Dave says, last week, I saw a ladybug on a leaf. Well, and let's say you then, in reliance on that, go out on a hike to see if there's a ladybug out there. I'm picking a ridiculous scenario, but actually, this is probably a better example of causation. You should know that the ladybug there a week ago probably isn't still there today. So you'd have a hard time establishing that I went on this hike and wasted my time because I was hoping to see a ladybug there. But it also is probably relevant to being material. In other words, fraud must be material. It must be significant. It can't just be light and frivolous. and it has to directly relate to the injury or the harm that has been suffered by somebody. Also, there has to be some degree of knowing reliance. For example, if I tell you, oh yeah, I'm so looking forward to going to Minnehaha Falls Bandstand to see a band, my favorite band who's going to be playing there on Wednesday. If I'm just telling you because I'm excited about it and I didn't know you were going to rely on that and you were going to cancel plans somewhere else in order to also go to that event, you can't sue me for the fact that you canceled your plans and may have lost money for those plans. Why? Because I didn't know that you were going to rely on my statement to then go change your plans. Now, if you said, oh, wow, that's great, I'm going to go cancel my plans. Now, all of a sudden, there at least is knowledge on my part that you are going to alter your behavior based on my statement. Here's a scenario that I've seen come up. You have a company engaging in fraud and trying to bring in customers for a particular service. And to give an air of legitimacy to the fraud, the company will hire an attorney or an accountant to give a letter regarding the legitimacy of the opportunity. And they might even hire 3 attorneys until they finally get one who will say exactly what they want. And they then use this letter from the attorney or accountant to provide to potential victims of the scam. And so the question then comes up, is the attorney liable for the fraud? But because the attorney wrote the letter that is now used by the company to perpetuate the fraud. And the answer is, if the attorney knew that that letter written by the attorney would be used by the company to mislead people, then with all other things being equal, that attorney is also going to be liable. Because the attorney knows that the letter is being used to mislead people. So even if the attorney wrote the letter to the company, by writing that with knowledge that others will see it and rely on it, the attorney is incurring potential liability. One other factor here is there needs to be actual damages. So if, let's say, for example, Emily says to Dave, Dave, there is an incredible sale down at this store, and you will, if you go down there and go to the store today, you will get 50% off everything. So and let's say Emily knows it to be false, and Emily is just saying it so Dave will get out of the house. Okay, so you have a fraud, you have a false statement. Emily's saying it knowing that Dave is going to rely on it, and she's trying to get him to rely on it. She's inducing him to rely on it. If prior to Dave leaving, Emily says, hey, Dave, you know what, I was joking, or I found out that the sale no longer is happening. Let's just use for a scenario that it's an actual lie, where Emily says, Dave, the sale has been called off. And Emily knows there never was a sale to begin with. So now you have 2 frauds. 1, Emily lied to Dave about the sale. And 2, Emily said it was called off when there never was a sale to begin with. Can Emily be liable to Dave for fraud? No. Even though fraud was committed, there were no damages because Dave didn't do anything that harmed him. Now, if he had actually driven down there, you'd have at least some argument for damages. But Emily mitigated the damages by giving Dave new information, even though it was fraudulent, that prevented Dave from taking action on it. So this comes up a lot when people initially contact me and they say, the other side committed fraud. I ask them, well, how much money did you lose from it? And they tell me, oh, we didn't lose anything actually because we figured out the fraud, but we still want to sue them. And I explain to them, well, you can only sue for damages. So unless you were actually harmed from the fraud, you have nothing to sue for. Now, there might be scenarios where you might have a basis to sue under other doctrines, but that's beyond the scope of this video. All right, if you have questions about this, feel free to add them in the section below. Just to kind of recap, here's what fraud is. A false representation by a party of a past or existing material fact that is susceptible of knowledge, where the information is false. It was made while knowing it was false. It was with the intention to induce another person to act. And the other person did, in fact, act in reliance on that. And the other person suffered financial harm from that reliance. That, in broad strokes, is what fraudulent misrepresentation is. All right, next question from Ryan on YouTube. Is it illegal for a third party to secretly charge a fee to someone when they make a donation to a charity, especially if this third party does so without disclosing to the donor? Is it illegal for a third party to secretly charge a fee to someone when they make a donation to a charity? I'm not sure if I understand the scenario here. So first question I'd have is, who's making the donation to the charity? I'm guessing here that a person is making a donation to a charity through a service, and the service charges a fee for that convenience, and the service doesn't disclose that fee to the donor. Well, in general, fees need to be disclosed in order for the other side to be liable for them. So as a general rule, a person is not liable for a fee unless they agree to it. But there's a big exception there, and that is if it's understood that a service couldn't possibly be provided without a fee, then it's reasonable for the parties to assume some fee is being charged. So without more information, Ryan, it's hard to it's hard to know which exceptions and doctrines to talk about in this scenario. But I think generally there's guidance with two principles. Fees generally have to be disclosed, but fees don't need to be disclosed if it's reasonably understood that there would be a fee charged for a service and the fee is actually reasonable. Here's a different scenario, but relevant. I was one time contacted by a fundraising agency that was trying to raise money for firemen and firewomen who were injured on the job. And they asked me to make a donation. Their arrangement with the nonprofit was they would keep 80% of whatever was donated. So if I donated $100, $80 would go to the fundraising agency, $20 would go to the actual cause. The question then is that legal? The answer is it is, and here's why. Because my donation actually was going 100% to the agency helping victims who had served in the fire department. But then they would pay a fee to the fundraising agency equal to 80%. Now, is that ethical? I don't think so. Is it allowed in most states, or is it allowed in all states? I don't think so. Since this time, there have been a number of laws that have been passed to prohibit predatory fundraising practices where there is more money going to the fundraising company than there is to the actual charity. I asked the fundraiser about this, and he said, I realize that it seems unreasonable on the surface to pay 80% to the fundraising agency, but that's what it costs in order to hire employees to go out and raise the money. And if we didn't do this, the nonprofit, we get nothing. So at least 20% of the money we raise, let's say hundreds of thousands of dollars, is better than $0 to the charity. So that's at least the argument in favor of allowing fundraising agencies to take more of the money than is received by the nonprofit. But that was set up where the nonprofit had a relationship with the fundraising agency and a contract to pay 80%. And again, many ethics rules prohibit this, and then there also are some state statutes that prohibit that. How will your relationship with your attorney be changed by AI? This is huge. Your relationship with your attorney is going to dramatically change by AI over the next few years. Here's how. First off, you have the opportunity to use AI prior to working with an attorney. You can explain your scenario and ask, what legal concepts relate to this? What questions should I ask of my attorney? So you can open up ChatGPT and tell ChatGPT what's happened and say, what are the legal doctrines related to this? What are the legal concepts? What are the questions I should ask an attorney to figure out if the attorney has appropriate experience in this area? What are normal next steps in dealing with this? That way you can empower yourself with knowledge before meeting with an attorney. Next, attorneys are going to start using AI to gather information from clients relevant to a particular scenario. So for example, a client might say, hey, I have a problem with my tenant. I'm a landlord. I have a tenant with an issue. The tenant's not paying. Well, AI might identify for the lawyer what questions should be asked of the prospective client to identify what are the issues here, what are the problems, what are the relevant areas to discuss, and gather that information so the attorney can efficiently help the client. So essentially, you have AI on both sides helping with that. Many people debate whether AI will actually replace attorneys. And I think it's understood that at a minimum, AI will become a powerful tool for attorneys to help clients. And attorneys who are just winging it without the support of one of the most valuable tools available today will be disadvantaged when compared to attorneys who are leveraging AI to become more efficient, to become more comprehensive and careful and attentive to detail, and to improve the relationship that the attorney has with their clients. So as a business owner, I'd encourage you to use AI even prior to talking with your attorney, to help equip you to make the most out of a meeting with an attorney. And then second, and by the way, I'm talking about a new attorney. If you have an established relationship with an attorney who already knows you and your business, it's probably more efficient to just go straight to that attorney. But if you're thinking about hiring an attorney for something new, you have a lot to learn. What kind of attorney should you contact? What subject matter and knowledge should that attorney have experience with? What questions should you ask your attorney to vet them? What information should you provide your attorney in order to help the attorney do the best work for you? So I'm really excited. It's kind of, I see AI as like when the plow was invented and farmers could stop using hoes to turn over their, to rotate the dirt and turn over the ground. All of a sudden they could hook up a plow behind an ox or a horse, and they could leverage the power of the animal in order to overturn more ground. And then we had a big transformation to tractors, and all of a sudden tractors could do far more than animals could. Likewise, we have a huge transformation happening right now in technology. There is a new tool for professionals. Will it replace those professionals? You know, it's too far down into the future for me to speculate on that. But what I do know is for the next decade, the people and the professionals who utilize AI will have significant advantages because that tool provides efficiency and strength that was not previously available. All right, next question. What is quantum Meruit and quantum Valebat? Frankly, these are Latin terms. I'm not even sure if I'm pronouncing Valebat correctly. It's spelled V-A-L-E-B-A-T. I looked up online before I hopped on here today to see how do you pronounce that. And there were differences of opinions because there's the Latin version, there's the American version. But let's talk about what these concepts mean. And why you might say, why should I care? Why should a business owner care about quantum Meruit and quantum Valebat? You should care because it's a really important legal doctrine that can protect you if you don't have a contract in place. So when you don't have a contract in place and you provide services or products for another person, you are entitled to reasonable compensation. Why? Because if you provide services, you're entitled to reasonable compensation under the common law doctrine of quantum Meruit. And if you provide products to somebody, you are entitled to reasonable compensation for those products, even if you had no contract, under the doctrine of quantum Valebat. What do these terms mean? Well, quantum means how much, or quantity, or volume. Meruit means the merit of something involved, or the value of something involved. So, what is the value and the quantity that was provided? That's essentially what quantum Meruit means. So you are entitled to be provided payment for the value of the services that you provide. Let's talk about Valebat. What does that mean? Well, in the context of quantum Valebat, Valebat means as much as it was worth, or the value of goods and products. So let's say, for example, you may not have an actual contract. So the other side says, let's say, I'm interested in 100 of these products shipped by Wednesday. And you then ship those products to this other party by Wednesday. And the other party says, you know what, I was interested. We don't have a contract here. I never agreed to actually pay for them. And we didn't even talk about terms and what the cost would be. And so under a contract law theory, you probably don't have a contract because you didn't have an offer with necessary specificity of terms and an acceptance of that offer. So you may not have a contract, but let's say the other side says, but I'm going to keep them because you willingly gave me these 100 products. So I'm going to keep them. Am I going to use them? Do you have a right to be paid for this? Yes. Under quantum Valebat, you have a common law right to be paid the reasonable value of the products you provided. Even though there is no contract, because the other side kept those products, you have a right to a reasonable payment for them. Likewise, with a service, if the other side accepts the value of a service, you would have a right to be paid for that. Let's say, for example, that you are a painter and you're going home to home, and you walk up to someone's home and you sit and talk with them about the color of the paint that they want and when you can complete it by, and you say, hey, I can start tomorrow morning. Everything seems good, but they never actually said, I accept, or great, let's do it. So you might have made a very clear offer. And then let's say they see you drive up the next morning to paint the house. You start unloading your paint, you put the ladders up on the house, you lay out the painting mats. It's very clear that you are about to start painting the house. And let's say the homeowner goes, ha ha ha, I never agreed to pay. We talked about the contract, or we talked about the what they would paint and maybe even what the cost was, but I never agreed to it. And so the homeowner just simply goes along gardening, maybe a nice little wave to the painter as the painter opens the paint cans and starts painting away. The homeowner might have a strong argument that there never was a contract. But under the doctrine of quantum Meruit, the painter is entitled to payment, even though there's no contract. Because of quantum Meruit, the painter is entitled to be paid for the value of the services received by the homeowner. The homeowner had an opportunity to say, no, don't paint. I never agreed to it, but instead just gave a little wave, implying to the painter there was no objection to the painter proceeding with the paint. That's a hypothetical, but it gives you the idea of what quantum Meruit is. And you'd be amazed how many times business owners don't have contracts and provide services or products for each other. And one side decides, oh, they're not going to pay for it. Now, one thing to keep in mind with quantum Meruit and quantum Valebat is you are entitled to be paid for the value of the services to the extent it provided a benefit to the other side. The payment amount is based on the benefit, not what it costs you, not what your standard prices are. And by the way, too, this is under the common law. There may be statutes in your state that provide additional claims or bases for relief. For example, the Uniform Commercial Code, known as UCC, provides for compensation for if you are providing products. Now, there are certain rules around bringing that claim, but that is a very related doctrine. And so if you're actually suing, you would probably sue for quantum Meruit if we're talking about providing services, or quantum Valebat if we're talking about goods and products. You might sue for promissory estoppel and breach of contract for both of those. And if you are suing for a provision of contracts and goods, you would probably also sue under the Uniform Commercial Code in your state. So quantum Meruit, quantum Valebat, Very important concepts for business owners to understand, because even if there is no contract, a party has an obligation to pay if they receive value in the form of goods or services from another party. All right, next question. What are membership units in an LLC? Well, in a corporation, which is a legal business entity, a company, the symbol of ownership is called shares or stocks. And those are owned by the owners, which we call shareholders. In an LLC, the ownership of the company is by the members, and their symbol of ownership is called either units or interests. So, for example, instead of saying a shareholder owns stock in a corporation, if you're talking about an LLC, you would say a member owns units in a limited liability company, or a member, the owner, owns an interest in the limited liability company. You might say, why are they called interests versus units? Well, limited liability companies allow a lot of flexibility for the owners to figure out how that LLC looks. It's called the power of contract, and you can put together, there's a lot of flexibility to contract with the other owners about the shape and rules of your LLC. Sometimes business owners say, we're going to model this more after a partnership, and a partnership's ownership interest is called a partnership interest. So just like owners of a corporation have shares, owners of a partnership have a partnership interest. So an LLC can adopt that concept and call it their ownership a ownership interest or a member interest. But an LLC might want more of a corporate model or corporate terminology. And so when owners of an LLC are writing up their operating agreement, which is essentially the bylaws for the LLC, the owners of the LLC can call the ownership interest a unit or a membership unit. And that is much more similar to the concept of stock or shares in a corporation. So prior to LLCs, we had corporations and partnerships. Those were the two primary entity types that could have multiple owners. But then when a LLC was created, it is essentially a blend of partnership law and corporate law and a new framework for business owners. And so there's still a lot of flexibility in how business owners set that up. This highlights why some of these online services that draft templates for LLC startups often are more harmful to business owners than helpful. I can't tell you the number of times that business owners have used Rocket Lawyer, LegalZoom, Harbor Compliance. I'm going to name them. These are template services out there. And although they can have some really good stuff and help some people, I have seen substantial legal problems and litigation and fighting among business owners who unknowingly agreed to these massive templates without having any understanding of what the terms meant. I would rather see you use ChatGPT to figure out the terms of an agreement that are relevant to you and you understand, and then agree to those, then sign some template that you don't understand that was provided by some online service and has all sorts of language in there stating what you will do and what your understanding is and how things will be handled when you don't understand it. And by the way, if there were a perfect template, everybody would use the same template. But instead, all these services have a different one. The Bar Association offers templates. Often you have other associations that offer templates. If you want to find all the templates for a contract type online, just hop into Google, type the name of the contract that you're looking for, like independent contractor agreement or website design agreement or stock transfer agreement. And then after the search term, enter this: file type : PDF. That says, Google, just give me PDFs. And when you do that, you will see all sorts of templates. And in each one are different terms and conditions and provisions. And rather than just adopting all of the provisions in the template you happen to find, I'd recommend, if you can't hire an attorney to do it right, because it's a smaller transaction or your budget doesn't allow, at least spend the time to use artificial intelligence to craft a contract that reflects what you really want. So you're not just blindly accepting a bunch of terms in the first template that seemed relevant to your scenario. All right, next question. What are business entities? This is a great question because it is so often lawyers and CPAs assume everybody knows what a business entity is. But that's kind of a technical term that most business owners don't know unless they actually had some sort of education in the technicalities of this. But a business entity essentially means corporation or LLC. Those are the big ones. And the reason we say entity is because generally the law treats this organization as separate from the individual owner. Now, another area is partnership. Is a partnership a separate entity? Well, in some ways, yes, some ways, no. But generally, when lawyers and accountants are talking about business entities, it's a reference to corporations and LLCs. And there are all sorts of different corporations. There are public benefit corporations. There are nonprofit corporations. Likewise, there are different LLCs. There are nonprofit LLCs. There are series LLCs. There are LLCs that are used for very niche purposes. But those are major entity types. What are other entity types? Well, a trust is often considered an entity, but it's not a business entity because a trust is used for purposes much larger than business entities. So when we talk about business entities, generally we're talking about LLCs and corporations and the variety that can exist within those worlds. Next question. What is a sole proprietorship? Whenever you start doing business and you don't have an LLC or a corporation and you don't have a partner, you have a sole proprietorship. You don't have to register it. It doesn't have to be filed anywhere. A sole proprietorship is when you are doing business. Sole means one, so you're the only person in it. And proprietorship essentially means business. So it's a person in business. That's all it means. Now you might say, do I need to set up an LLC or corporation in order to deduct the business expenses of my sole proprietorship? No, you don't. Not in the United States. In the United States, when you have a sole proprietorship, you're taxed on the profits, not the total income. So once you have the total income, you deduct the business expenses, and then whatever's left over, those are your profits. That's what you pay tax on. And that is done on Schedule C of your federal tax return. So what is a sole proprietorship? It's anyone in business who doesn't have another partner, doesn't have an LLC, doesn't have a corporation. You're just in business for yourself. No registrations required. It's the easiest way to get into business. What's bad about a sole proprietorship? Well, you're personally liable for everything. So anything that goes wrong in your business, you have personal liability for that. That's why sole proprietorship is usually used when you don't have any employees and you have a small business operation. But once you get to a certain size, it justifies setting up an LLC to limit your liability, or a corporation, which also limits your liability, so that you don't have personal liability for certain business activities. So if you have a sole proprietorship, it just means you're in business. But as you grow, think about getting an LLC or a corporation, such as an S corporation. Next question. What is a limited liability company? I love these questions because it may be clear to lawyers and accountants who have extensive legal training what a limited liability company is, but we often throw around these terms as though everybody understands them. And yet there are a lot of misunderstandings associated with limited liability companies, or LLCs. So first off, in order to have a limited liability company, you have to actually have an LLC registered in a state. It requires registration. Once you have that registration in place, it does have to be maintained. Usually you have to do an annual filing to renew it. Now, if you miss that annual filing, many states have a safe harbor where you can file and pay a fee, and it reactivates the company as though it had never lost its LLC status or had never been terminated. All right, so that's how you set up an LLC. But what is it? A limited liability company is a company, so a business organization that is recognized by state statutes in your state. In other words, if you're in California, you have a California LLC under California law. If you're in New York, likewise, it's under New York law. So you have a different set of rules or laws under which you are governed. So you've chosen to be governed under a set of rules for your organization. And by doing that, you get the benefit of limited liability. Well, why don't we say unlimited liability? Because you are always liable for your own acts. So let's say I have an LLC. It's a restaurant, and I have a bunch of employees. And I also work there. And I walk around, and as I greet the customers in the morning, I say, hey, can I get you a little more coffee? It's a little way to bring some warmth and cheer and allow customers to get to know me as a business owner. Let's say I accidentally spill some hot coffee on someone and it injures them. Let's say they then sue me and the business. Do I have a right to say, no, I'm not personally liable because I have an LLC and this was an injury that occurred at the business? No, I don't, because liability is limited. It's not unlimited. My liability is limited, but I'm always responsible for my own conduct. Now, what kind of liability is limited? In other words, for which circumstances could the customer not sue me as the owner? The customer can't sue me if the injury was caused by another employee of the company or something that I wasn't directly involved in. Although I'm always responsible for my own conduct, if there's an injury caused by somebody else within the company is liable, but I as an owner am not necessarily liable. Now, if I'm the president of the company, I might be liable for negligent hiring or negligent supervision. So let's say, for example, I'm the owner of a bus company that sends children or picks up children and takes them to school. And I hire a bus driver and I fail to do a background check and determine that that bus driver is a sex offender. And let's say hypothetically, and this is a horrible scenario, but let's say there is a misconduct on the part of the bus driver towards the children in the bus. And the parents of the children sue me personally. On one hand, I can say limited liability. As the owner, I'm not liable. But if I'm the president of the company, I have a responsibility to not be negligent in hiring. In other words, to be reasonable in the hiring process. And if you're going to hire somebody who's going to have supervisory duties with children, it's important to run background checks on those people. So that would be a scenario where the parents could likely prevail against me, not because I'm the owner of the bus company, but because I was the president of the bus company and failed to have proper supervision or hiring processes in place to prevent a sex offender from engaging in misconduct or even serving in that role. So, what is a limited liability company? It's an organization allowed by your state law that gives you the benefit of limited liability, so you can't personally be sued as an owner, as long as you follow the rules under the LLC law in your state. All right. What is contract law? What is contract law? What is a contract? A contract is an agreement between two parties or more. And what exactly is involved in that agreement? It has to have a few pieces. It has to have an offer. That offer has to be accepted. There has to be sufficient specificity in the terms of the offer. So, like, for example, price, delivery date, quality, description of the product or services to be provided. And there has to be consideration. Consideration is a legal term. And so because it is essential for business owners to understand a contract, I'm going to talk for a moment about consideration. The simplest way to think of consideration is a benefit. So in other words, one party has to be doing something for the other party at least. And normally there's a benefit going both ways. For example, if I say, I'll pay you $100 if you paint my house, the consideration is $100, and the consideration is the service I'm receiving of you painting my house. So if you have just a one-way transfer, that's usually a gift, not a contract. It might still be enforceable under the doctrine of promissory estoppel, but that's a topic for another day. Here, the question is, do you have a contract? And there has to be consideration. Well, you might say, when possibly could there be a contract where there's no consideration? I'll give you an example that comes up all the time with business owners. Imagine you have an employee who's been working in your company for a while, and then you decide, you know what? I'd like to have this employee be given access to some really important information, some trade secrets that I don't want any of our competitors to know about. So I want the employee to sign a non-compete agreement, which says for a 100-mile radius, you won't go work in this particular industry with these competitors. And so you go to your employee and say, hey, look, cool opportunity. I'd love to bring you involved, but because of the confidential nature of this, I want you to sign a non-compete agreement. And if you don't, I'm not going to be able to move you to this department. And the employee says, oh, sure, I'll sign that. And then time goes on. The question is the employee bound to that contract? Well, you as an employer might say, well, of course, they agreed to it. But what did the employee get? Because remember, you're getting a promise that the employee will not compete. But what did the employee get for signing that? Well, employers have said, well, the employee got to keep the job. And courts have said, no, that's not enough. That's not consideration. That's not enough of a benefit to the employee. Now, There have been a few scenarios where employers have shown the employer relied on the employee's representation. And as a result, the employee was given access to these trade secrets and given additional training and given raises and worked there for a number of years. And in those cases, the court have said, you know what, all this stuff piles up. And even though generally speaking, the employee wasn't compensated for signing that non-compete agreement, all these other things added together are enough that we think it would be unfair for the employee to be able to go out and compete and argue that that non-compete is not enforceable. So we're going to consider all that stuff given after the fact to be consideration. But that's an exception. In most cases, the courts say if the employee is not paid something over and above a salary to sign a non-compete agreement, there is no consideration, and so the employee is not bound to the non-compete agreement. You might say, well, how much money? Generally, $500 to $1,000 is going to be sufficient. It's at least a significant amount. Now, the employee may argue that it wasn't a fair market rate, but that really isn't the standard for consideration. Just think about it. If you had a contract was not enforceable unless it was based on fair market rates, a lot of contracts would be thrown out because a lot of contracts have discounts or rates that are not fair market value. So it doesn't matter that the consideration is a fair market rate. It just has to be some consideration. And I would go more than $1 because I think you might be asking for trouble if it's just $1. That doesn't necessarily feel like good faith. It feels like you're just trying to check a box. Because at the end of the day, the question will be, will a judge believe that there was some compensation for the employee signing the non-compete? And $1 just feels like a de minimis amount or a mere token without any actual value. And so I think that it's risky to throw in $1 as consideration. Historically, $1 was used, and there are a number of cases where $1 was sufficient. But let's face it, that's before $1 was worth what it is today. $1 was worth a lot more in the past. And so these days, at a minimum, you should throw in $100 as consideration. But depending on the circumstances and the size of the contract and what you're asking the employee to give up, you probably want to pay the employee a lot more to ensure your contract has consideration. So what is a contract? It's an offer by one side, which is then accepted by the other side. And we assume the offer has to have sufficient detail because, if there's not a price or there's not a product, that probably, in most cases, but not all, is not sufficient detail. And then finally, you have to have consideration where both parties are getting something for the transaction. As a general rule, that is a contract. Of course, there are a lot of exceptions. One exception is the statute of frauds. The statute of frauds is a state statute that lists certain types of transactions that are not enforceable unless they're in writing, or the other side admits that they agreed to it. So under the statute of frauds, a contract of certain type has to be in writing, or the other side has to admit that they agreed to it. So that's a quick summary of what is a contract. You might be wondering, can a contract be oral and not in writing? Sure. Can it be an email? Sure. Can a contract not be spoken at all, but be understood by the circumstances? The law says yes. Here's how that works. Let's say I am painting, let's say I'm seal coating houses. Seal coat is when you put a protective cover on asphalt. It's a tar-based cover to protect the asphalt from rain and wind and erosion and fill some cracks. And let's say I'm going on down the street, and the let's say, for example, the business owner or the homeowner comes to me and says, "Oh, I'm so glad you're here. We all need our driveways done today." Um, and let's say the homeowner says, "I sure hope you have time to do everybody." And then let's say you say, "Hey, I'm charging $100 per driveway," and the owner says, "That's a good deal. That's a really good deal because mine would be like 150 with most places. That's a good deal." So we didn't have a specific offer where the person providing the service says, "Hey, I'll do your driveway for $100." And you don't have the homeowner specifically saying, "I accept that offer. Come do my driveway." But let's say I then show up at the driveway and I start unloading. Um, and the homeowner looks up and smiles at me, acknowledges I'm there, and I'm about to seal coat the driveway. I then seal coat the driveway and I go to get the check from the homeowner for $100. And the homeowner says, um, "I never agreed to a contract with you. I don't owe you for this. You didn't offer to do my particular driveway. I didn't accept." Is there a contract in that scenario? Well, under a court could conclude that there was uh, an offer and acceptance by the conduct of the parties. Even though there was not an express offer and acceptance, the conduct of the parties made it clear. You might say, isn't this similar to quantum Meruit? And the answer is yes. In fact, usually in a scenario like this, you will have a claim for breach of contract based on the conduct of the parties and a claim for quantum Meruit. You'd probably also have a claim for unjust enrichment. So when this video is done, we'll put links to resources for those different concepts so you can learn more about them. If you're interested in this topic, those will be of interest to you as well. So yes, a contract can be by performance. Here's another example where contracts can be by performance. Let's say once a month, I call you and order 100 widgets for $100. And let's say after 8 months, I don't call you, but you still send those 100 widgets. And let's say I say, "You know what? I didn't order those. I'm going to keep them, and I'll pay you for them, but I'm not going to pay you the standard rate." Under the the doctrine of course of conduct, which is the conduct between two parties, the fee or the price that I owe is going to be assumed from the prior conduct between the parties. So even though there may not have been a contract at all in that particular month, the fact that we've had month after month of the same contract for a certain price allows that price to be injected in there as the lawfully enforceable price under the course of conduct doctrine of contracts. It would also be relevant under the Uniform Commercial Code, which is probably a separate claim. It would also be relevant in a quantum Valebat scenario. And I'll put links in the video below to those other doctrines. If you're interested in this area, those may be of interest to you as well. All right, next question. And then we are about to wrap up. What is workplace safety? Well, if you have a business, you have an obligation to comply with all laws. Typically, that's going to be OSHA laws. You have state and federal obligations for preserving safety and compliance with all of those laws, whether passed by the legislature or regulations, which are laws established by government agencies authorized by the legislature to set up those laws. So, statutes and regulations, you have a duty to know all of them for your particular industry. In addition, you have a duty to act as a reasonable person would to avoid unreasonable injury, unsafe work conditions, etc. So that can be frustrating for business owners. Think about it. You are held to all these standards which you don't necessarily know. And so that's why, as a business owner, one task is to figure out what are federal and state laws that regulate safety for your particular type of business. Now, if you have a business that has a heavy equipment or machinery or construction or some sort of physical risks, there are going to be a lot more safety issues there. Likewise, if you're dealing with chemicals or various materials that have harmful elements to them or hazardous waste, you're going to have very strict rules on workplace safety as it relates to those. For general business, though, the idea is you will take reasonable measures to make sure that your office is generally safe. Now, if you don't provide an ergonomic chair to everybody and people start getting sore backs, is that unreasonable? Well, to figure out what's reasonable, we often look to what do other businesses do? Not every business provides an ergonomic chair. But if you have somebody who comes to you and says, hey, this chair is really hurting me, it doesn't fit me right, you may have a workplace injury risk present. And it is a best practice once you have been brought to the attention or once a risk has been brought to your attention, you act as a reasonable person would in dealing with that risk. And usually that means providing some sort of reasonable accommodation to somebody. Now, obviously, leaving wet floors around the office is unreasonable, even if nobody complains about it. If you're walking by and you see wet floors that somebody could slip on, that is going to be the type of unreasonable workplace environment, and you then would have liable for those injuries. Now, here's another important thing to know. Often in states, businesses have liability for any injury that happens in the workplace, even if the business didn't act unreasonably. And often there is workers' compensation insurance, which may be mandated by your state laws to cover the costs of that. States like Minnesota have set up a workers' compensation policy where companies need to pay into the workers' compensation fund, and then when employees are injured on the job, they qualify for workers' compensation benefits. So that is, in a nutshell, workplace safety and what business owners need to know to avoid legal problems and legal trouble as you hire employees or have customers at your workplace. If you would like more information about any of these topics today, if you are interested in a business owner and getting educated on common mistakes business owners make and how to avoid them yourself, you can go to aaronhall.com/free and sign up to get a number of videos and other resources to help equip you prevent problems in your business. This is for entrepreneurs, startups, business owners, CEOs. Generally, I'm thinking about companies with under 500 employees, even as few as 1 or 2. Because for you as a business owner or a future business owner, you can either prevent these problems or pay the much more expensive cost of having the problem and having to clean it up afterwards. The purpose of this YouTube channel is to help you avoid problems, to grow your company, provide a great value to your customers and clients, create a great environment for the people that you work with, and experience the success that comes from having a good company built on best practices. I'm Aaron Hall, an attorney for business owners and entrepreneurs. If you have questions about any of this, feel free to put them in the comment section below. Look forward to seeing you next time.